whether this compensation cess benefit would be given to the dealer or to the industry where they are having balance with them. The candid, straight, plain answer was that in these type of rate rationalization, some casualty happens. Okay, so this compensation cess benefit, in view of the board, in view of the, I would say, bureaucracy, or so, I'm not sure to what extent the finance minister or GM had discussed this aspect, though it has not come anywhere. But the view what getting developed is that law presently does not permit this refund or setting it off against the GST liability. So government is not willing to give this benefit as of now. Let me now bring a bit perspective from the legality perspective as to what the law is, what has been the legal position of similar cases in the past, and what business can look at now in terms of looking at from the compensation cess. So when Sudhir was touching on the preamble to the cess, yes, he touched upon it was to compensate the state for a specified period. So if you look at the cess entire this devolution of fund collected under the cess account, entire fund goes to the state governments. No portion of the compensation cess is retained by the central government. And the amount what is going to the state government is to compensate for the loss. And this amount is coming to them nothing but in the form of a GST, in the nature of GST, within the framework of GST law, constitutionally and legislatively, both perspectives. Okay. If I go little deep dive into the within the Cess Act, so Section 7 provides for distribution of cess to the state government. Section 11 provides the mechanism to utilize this cess, where it says that cess can be utilized for the purpose of paying the cess liability. Now there is another section 9 which provides that the provision of GST law shall mutatis mutandis apply to the Cess Act wherever the Cess Act is specifically not mentioning anything about. Now for this particular example of motor car, which earlier was subjected to cess and now only GST, because cess will cease to exist, it becomes a non-taxable supply from the perspective of the Cess Act. And this mutatis mutandis provision in the Cess Act takes me to Section 18 of GST Act, where it says you need to reverse the credit available with you. Once that provision kicks in, technical reading, first blush reading gives a message that from the cess perspective, it becomes a non-taxable supply. So I need to reverse input tax credit of the inventory or the cess on the inventory lying with me. While my ECL balance of cess could be lesser or higher than that amount. Okay. But what the provision says that I need to reverse to that extent. Maybe I'll take another example of Delhi High Court in Court Cellular Operator Association of India. So there what had happened in April 15, where the cess was merged with the service tax also. So any capital goods, whatever were lying with me or whatever I had paid the cess, whatever was balanced with me, and when the set-off was permitted for the future period, whether the opening balance can I set it off against or not. Unfortunately, there also High Court had taken a view that in the absence of a clear mandate in the law, you cannot utilize the cess against the service tax liability. So these type of jurisprudence are there, which are, I would say, not in favor of the trade, but we need to distinguish between those jurisprudence versus the position now. Because the cess here is within the framework of the GST law itself. And once it is within the framework of GST law, setting it off against GST, a nature of GST itself, I think would be an ideal proposition. But can it be done today? Looks that the government intent, direct legislative provision, and portal restriction may not permit it the cross utilization. It is certainly a legal battle which one may have to win only by going to the High Court